I have a PIMSEC presentation for the broadband that clashes, but I will ask Senator Golding to chair, and I will be back as soon as we present. So I'm just apologizing, but I will leave the unit on, but I won't be on for a little while.
Very well, very well,
you have that,
very well,
right?
Minister.
Yes, Chairman. We were in the process of selecting a chairman, Chairman.
What is the process if the chairman has divested the responsibility, or can the chairman do so?
The chairman can do so.
Ms. Brandon, are you hearing me now?
Yes, I'm hearing you, Chairman.
Yes, I'm apologizing to the members. I have a presentation on PIMSEC, which is on as we speak. So my instrument will be on, but I'll be off for a while. And I've asked Senator Golding to chair in my absence.
Okay, Chairman.
All right. Thank you, Chair. And afternoon to all the members. I'm so sorry. Let me get this video going. Okay. Is that on now? It's not appearing to be on. Okay, there we go. All right. Afternoon, members. Calling the meeting to order on behalf of Chairman Minister Vaz. Can I ask a member to say a prayer, please? Who do we have on? Senator Gill, thank you for volunteering.
Let us pray. Most merciful and heavenly Father, we invite you to these proceedings because you know we can't do it without you. In these proceedings, we need your guidance. We need your ear, your thoughts, and your mind to guide us, to explore our own thoughts, to mold words together so that we can represent. These we ask in your merciful name. Amen.
Thank you very much, sir. Thank you very much. One moment, please. Craving indulgence of the committee. Apologies. Okay, moving into the agenda. Are there any apologies for absence, Ms. Brandon?
No, they are not, Senator Golding Campbell.
Okay. That said, can we move straight into the substance of the agenda, please? I'm trying to pull up the agenda. Members would have gotten it, I think, a couple of days ago. So the first item on the agenda would be the reading and confirmation of the minutes of the meeting held on June 23rd, 2022. And I'm anticipating that members have had a chance to review it. Ms. Brandon, when were the minutes sent out again?
And they were sent out last week.
Okay. So assuming they have been read, can we take the minutes page by page quickly? So I'll take look at page 1, page 2.
Page 2, Madam Chair. In the paragraph at the bottom, the sentence that begins, he added that research done by the LRD found that the use of some of the terms were unconstitutional in various cybercrime legislation because it was thought to be too vague and persons could not. I don't think the not should be there. It should. I read it as and persons could. I understood it as and persons could direct their actions. I don't think the word not should be there.
The use of some of the terms were unconstitutional.
And it does change the meaning significantly.
Unconstitutional. Not to be too vague. Yes, I think I agree. Could the committee clerk note that, please? All right, any further on page 2? If not, moving to page 3.
I'm sorry, Chair.
Yes.
Andre Basco here from the Legal Reform Department.
Yes, Mr. Basco, thank you.
What we were saying, actually, we do think that the word not should be there. The point we were making was that when there were provisions in a law that didn't have a definition, such as the ones in the laws that were found to be unconstitutional, the court found that in the absence of a definition, it would be difficult for people to direct their actions. So they wouldn't know what would be considered obscene, for example, in the absence of a definition. So that was the point we were making. So we do think that the word not should be there.
I guess
Okay.
I was thinking like a criminal and saying, thinking of persons being able to direct their actions so as to avoid the law.
Okay. Okay. All right. The clarity has been given. Thank you, Mr. Vasco.
Before you go, Chairman, so the word not should be omitted?
The word not is supposed to be there, so there should be no change to that sentence.
Noted.
Okay. From page 2, we move to page 3. No corrections to page 3. I'll ask the members to direct their attention to page 4. Page 4. I now ask the members to direct their attention to page 5 of the minutes. Any corrections to page 5? Can I just make a correction to page 5, bottom paragraph, second sentence? Senator Campbell Rodriguez stated that many damages from cyber-related offenses were psychological. If I can remember my English grammar, I think that would be better stated as that most damage from cyber-related offenses are psychological. Not in the past tense, but in the present tense. Going further down page 5 and now moving to page 6. Are there any corrections to page 6 of the minutes? There being no corrections to page 6, could the members direct their attention to page 7? Page 7, any corrections on page 7? The second sentence in that last paragraph, I believe, ought to be he defined macros, not marcos. Any further corrections to page 7? If not, could the members take a look at page 8? Page 8 of the minutes, dealing with the topics of spear phishing, smishing, search engine phishing, vishing, and farming. There are no corrections to page 8, and I'm assuming, members, that if you're quiet, that means you have no corrections to propose to the page. Then we move to page 9. Page 9, continuing on with farming and clone fishing, man in the middle phishing attack, business email compromise, and malvertising. There are no corrections to page 9, then can we move to page 10? Page 10 of the minutes. There are no corrections to page 10 of the minutes, then can we move to page 11? That begins illegal selling or trafficking, cyber-enabled crime. Any corrections to page 11? If there are none, then can we move to page 12? Just at the bottom of page 12, that starts the sentence, Senator Gale asked if the means used to extort were captured in the general provision. Is it means used was or means used were? I defer to anybody else who can. I'm not actually quite sure. Hello, morning members. Good morning.
Present.
Thank you. Can somebody? Is that was to be were? It's a minor grammatical question. Ms. Brandon, can you just check that for us when you're looking back at it, please?
It was, Madam Chair, I think it was, it is meant to be was because the word means is being used as
Method.
the method.
Yeah.
And
Okay.
as such, it would be was.
Okay. Thank you.
Mhm.
Moving to page 13. If there are no further on page 12. Page 13. Any corrections to page 13? If there are no corrections to page 13, then can we move to the last page of the minutes, which is page 14? Okay. Those being the minutes and subject to the what are I think are minor corrections. Can I have a motion that the minutes be confirmed? Is that how I do it, Ms. Brandon?
Yes,
So
Senator
moved.
Golden Campbell.
Thank you.
So moved.
So moved.
Okay, so that was moved, Senator Gale, seconded by Senator Campbell Rodriguez. Thank you both. All right, moving on to the rest of the agenda. matters arising from the minutes. Do we have a list of matters arising?
Madam Chair, if you notice from the minutes, we asked that last week it was asked, it's on page 14 of the minutes, that a list of action items would be sent to the MSET team to make our lives easier, but I don't know if that was taken on board for this week. But it was suggested as per the minutes of page 14 of the minutes of the last meeting.
Yeah. Ms. Brandon, can you assist? Do we have a list of action items that could guide the committee?
Okay, would you wish for me to read them out?
There is such a list?
Of action items or matters arising from the minutes?
Well, the matters arising from the minutes would, I think, be the action items of that meeting.
Okay, so in terms of the proposal for provision being inserted in the act to address the different types of social engineering tactics, such as phishing, I was advised by the ministry that that update will not be provided at today's meeting. However, the technical team will further discuss that matter and then get back to the committee on it.
Okay. All right. That was the only action item?
And also in terms of a suggestion that was made by Senator Gale at the last sitting, he had suggested that the members further consider the proposed offense of cybercrimes, and the committee is to make a decision on it.
Cybercrimes?
Cyberbullying, sorry.
Cyberbullying, okay.
Yes. Mm-hmm.
Okay.
So that's basically it, Chairman.
Okay.
Madam Chair, no. Also on page 14 in bold, we see where an update is supposed to be given today. I don't know if we would an update is supposed to be given today on the matter of social engineering tactics.
That's a matter that Ms. Brandon just spoke to, that the technical team is deferring that to the next meeting.
No, that was bullying. I thought that was the bullying one.
No, she spoke to the social engineering tactics such as phishing that they've asked to defer to the next meeting.
Okay.
The cyberbullying issue was a suggestion by Senator Gale that we look at it further and make a decision on the proposed offense, because I don't think we had made a decision on that offense on the last occasion.
Okay.
So that is for the committee to further consider.
Okay.
So before we move into the examination of the matrix, to complete the matrix, part 1 of the matrix, and to take a look at part 2, which was have been delivered to the members, I think it was yesterday. Are the members prepared now to discuss further the proposed offense of cyberbullying? And if so, if there are no objections, can I take us back to that section? Ms. Brandon, can you just guide us?
No, Miss Senator Golding Campbell, I had a matter arising from the minutes.
Go ahead, Senator. Go ahead.
On page 13, the second to last paragraph, Senator Gale asked if members should examine the Education Act of Jamaica and its regulations. Ms. Simon responded in the affirmative and added that one of the approaches was a standalone offense for bullying. Where can we find this standalone offense for bullying? Because I've tried to find it in the Education Act, but I haven't. Where is it?
Aren't you talking about the same thing we're just about to embark on, Senator Campbell?
I don't know what you're about to embark on, because you said you were leaving.
I don't know if you were
hearing.
Well, I don't think you were hearing me. We're dealing with the matters arising. The suggestion by Senator Gale, which falls on the matters arising that the committee further consider the issue of cyberbullying and the proposed offense of cyberbullying. That was a suggestion at the
And what I'm saying, Senator Bowling Campbell, is
meeting. I think it's covered here in. Go ahead. I'm not hearing you. I think you're muted.
Referred to a standalone offense. Was it a standalone offense to be put in this Cybercrimes Act, or is it a standalone offense for bullying generally? Was that referring to the Education Act, which was referred to in the sentence before? I'm trying to just get an understanding of that. It would help me before we go into the substantive discussion that you're asking for.
Okay, well, it's part of the discussion. Can I ask the team to opine on that, please?
The reference to the Education Act, there isn't currently such a provision. My comment was to say that there is provision like that in other jurisdictions, and that we could consider doing that, because bullying itself is a problem as well. So rather than taking the approach of making it a cyberbullying offense alone, one approach would be to make provision for bullying in the education and or the regulations, which would then have effect under the Cybercrimes Act by virtue of Section 4.
If that is the case, then that means we have to correct the minutes, because the minutes says approaches that was that there was so it implies that one exists already. So we'd have to correct the minutes.
What section? What can you just point us directly to that
13. Page
Right.
13, second to last paragraph.
Second to last paragraph.
As I read what I'm reading here implies that there is a standalone offense for bullying existing somewhere. And that is why I was trying to get clarification. Where was it? Where is it? But what the LRD is now saying is that that's not what they said. What they said was one should be put in, which is different.
But it doesn't define where the standalone offense is found. But I can see how you could read that as it's found somewhere in Jamaican law.
Yes.
Having confirmed the minutes, can I ask the members to allow us to recommit the minutes, Ms. Brandon? And just to have that clarified so that it is clear and unambiguous.
Could you state where in the minutes?
We're looking at page 13, the paragraph that starts Senator Gale at the bottom, the penultimate paragraph. Senator Gale asked if the members should examine the Education Act of Jamaica and its regulations. Ms. Simon responded in the affirmative and added that one of the approaches that was found was that there was a standalone offense for bullying generally that was technologically neutral and would cover cyberbullying. He noted that children were also bullied at school. So Ms. Simon is referring to a standalone offense seen in other jurisdictions. Am I correct, Ms. Simon?
Yes, you're correct.
Okay, so if I could ask the members just to allow us to recommit the minutes and to confirm the minutes again with that correction. Can I get a motion so to do?
I'm in support of that, Chair.
Thank you, Senator Gale. Seconded by?
Seconded.
Senator Longmore, thank you so much. Okay, now I think we can move into that discussion. If members are so minded, would they wish to have that discussion now, or should we perhaps launch into the complete the offenses in part one of the matrix, and then we can have a more fulsome discussion on the cyberbullying issue?
So, Chair, just let me be clear.
Yes.
In terms of what I had asked. I did mention that cyberbullying is a real issue and ought to be treated with. My understanding is that there may be other legislations in other jurisdictions that could treat with it. And so we could import whatever is prescribed in those legislations to make an input in this present legislation that we're reviewing to solve the problem. And I was anticipating that the technical team, if possible, could have provided any such provisions for us to examine.
Okay, Ms. Simon, if I can take up where you opined in the minutes in relation to the offense being found as a standalone offense, the offense of cyberbullying elsewhere, but also your recommendation in relation to the offense of bullying generally. Is that something that discussions might have been held with the MOEY personnel to determine if that was a possibility?
No, we did not discuss it. That was what we were suggesting could be done. One of the things that could be done, MSEC could have those discussions with MP. We have not engaged in those discussions.
Okay. All right. So I think what Senator Gale is asking if we could have brought to the committee some examples of how it is treated as a standalone, and then I guess the technical team at MSET could give us their recommendation in terms of how it would be dealt with, whether as a standalone or as a general bullying offense dealt with under the Education Act. I'm not even sure if that is really the Education Act, because as I think about it now, wouldn't that be more about the child care and protection? Bullying doesn't just happen at school.
The recommendation was based off the fact that we had found legislation in Canada, in their Ontario, in their Education Act. Right?
It was okay.
I don't have a copy of it.
Okay, that's fine. To your recollection, did it? So the fact that it was in the Education Act, was it only applicable in this public school system? Do you recall? If you don't, that's okay.
No, I'm not
recalling. Okay, it sounds like we need to do a little bit more investigation into it before we start having a discussion on what the options are.
I hadn't realized that he had what was being requested was the fee samples of that. So I had not pulled any for this meeting.
Okay. All right. So then the ask for the next meeting then, Senator Gale, would be for you to see what those standalone offenses look like.
Okay.
That would be very helpful, Chair.
Okay, and I would also add to that, if I could, for the technical team, just to indicate whether or not, when you talk about examples in Canada in the Education Act, is that applicable only to the public school system? And if it is, are there examples in the broader protections that are afforded children generally? So in our jurisdiction, I would imagine that to be our Child Care and Protection Act. Because I don't think it would, and I did not think that the committee was talking about cyberbullying as it related to just being within a school system, and I suspect that's what Canada provides for. So if they could give us some guidance on that as well, I think that would be useful.
Well, I could say to the latter comment that the approach seems to be where it's not for the schools under the Education Act. They seem to use their general harassment provisions under the criminal code.
And that is Canada you're referring to?
Yeah, just Canada though.
Okay. All right. So let's come back with a sort of more fulsome answer to the question that Senator Gale has raised, and so the committee can properly deliberate on the issue. That would be my recommendation if supported by the members. Okay. All right, I'm taking silence as support. Okay, in that case then, can we now move to our agenda? Sorry, can we now move to our agenda item for our fulsome discussion, which would be a continuation of the matrix? I'm just scrolling through my documents here. Continuation of the review. So who is going to lead us through that? Is that CTD Murray? And if you could just remind us where we left off.
Sure. Good afternoon, Chairman. Good afternoon, members and colleagues. We left, well, we would have considered, the committee would have considered cyberbullying as the last, so we'd be picking up at page 46 of the matrix. And I'm going to refer to this as part one. Part one of the matrix, page 46, that's April 26, 2022 document. And we have 4 more matters to consider to conclude this particular matrix, and the Office of the Parliamentary Counsel, as well as the Attorney General's Chambers, will support on the 4 matters, and then the Ministry will treat with 1. But with respect to page 46, there was a recommendation by the, no, my apologies, I think, right.
I'm sorry, CTD Murray, let me interrupt you for a second.
45.
Did we cover, I was just about to say, because I was thinking we didn't cover that section on the Fingerprints Act at 45.
Sorry,
okay.
I was looking at the wrong page. All right,
No
so
problem.
we're at 45, and we're going to treat with the recommendation by the Office of the Director of Public Prosecution in respect of the Fingerprints Act. So the recommendation there was that all cybercrime offenses be brought within the framework of the Fingerprints Act, as these offenses are serious offenses. So therefore, where persons are charged with any offense under the Cybercrimes Act, and where they are convicted, their fingerprints should be taken and stored at the Criminal Records Office pursuant to the Fingerprints Act. So that was the recommendation from the ODPP. The Attorney General's Chambers would have been asked to consider the recommendation, and they have provided and would have provided a response, which I would just defer to them to take the committee.
Good afternoon, Madam Chair, members of the committee. I am Ashley Marie Auld from the Attorney General's Chambers. In regards to the proposal made by the Office of the Director of Public Prosecutions, the Chambers generally has no objection to the proposal. As on our review, we note that the penalties under both the Cybercrimes Act as well as the Fingerprints Act are similar and therefore not at variance. So for example, we note that the penalties under the Cybercrimes Act range from 3 million or 3 years imprisonment in the parish court to a fine or 20 years imprisonment in the Supreme Court. We do, however, note that the Fingerprints Act falls under the portfolio of the Ministry of National Security. And so we do recommend that the Office of Director of Public Prosecution's proposal be brought to that ministry's attention for their consideration. And further, if the ministry is in agreement, we note that the second schedule of the Fingerprints Act, which is what the Office of the Director of Public Prosecutions would be amending, it could be amended by the Ministry of National Security without awaiting a decision of the committee, as the Fingerprints Act provides that the act may be amended by the relevant minister by order subject to affirmative resolution. So therefore, if the Ministry of National Security is so minded, then they may amend the second schedule without awaiting a decision of the committee. That is all in regards to the proposal made by the office.
Thank you. Can I get the committee members' comments on this proposal?
Madam Chair, I'd be happy to, but I'm going to be very honest with you. I'm still struggling to figure out which document we're looking at. I'm at the back of the class today. So is it the
We
one
have two
labeled?
documents, and at the bottom of each one, it gives a date on it. So
Right.
so there are two. One is February 21, 22, and one is April 26, 2022. So
Okay.
it's the April
And what
26
page?
document at page 45 to 46.
Okay, thank you.
You're welcome. Members, any comments on this proposal from the Office of the Director of Public Prosecution that the Fingerprints Act be looked at in terms of capturing cybercrime offenses, that they be brought under the framework of the Fingerprints Act? I want to be sure that I'm getting members' input. I see
I'm in
Senator
support, Madam
Bunting.
Chair.
Chair, could you just repeat what the rationale the DPP's office is proposing for that? What was the rationale?
Well, rather than letting me repeat it, can I just ask Ms. All to repeat it,
Yeah,
please?
sorry. Yeah, I'm sorry.
Who's speaking from the Attorney General's chambers?
Sure. So the Office of the Director of Public Prosecution's rationale for this was that they want to send a signal that cybercrimes are indeed serious, and there is a regime under the Fingerprints Act which requires for convictions to be made where it is that there are, where there is that a person is charged. So, for example, the Office of the Director of Public Prosecutions would like to use this framework that is found under the Fingerprints Act in order to justify all the offenses that are going to be regarded as repeat offenses under the Cybercrimes Act. Did I make myself clear?
You probably did, but maybe I'm not understanding. What I'm trying to understand is what is the mischief we're trying to solve by including this in that if it's not included, it would solve. That's what I'm not clear on.
Sorry, Chair, members, if you don't mind, and if you don't mind, Ashley Marie.
Thank you, Sergeant.
A big part of it is that if you bring this under the regime of the Fingerprints Act, once persons are charged, you can take their fingerprints. So what happens under the Fingerprints Act is you have a schedule of offenses. And so what they want is for this cybercrimes offenses to be included in the schedule of offenses.
Okay, all right, I'm clear.
And then other things flow from it as well, but that's part of the whole issue. And then when you look now at the range of offenses, you can see that these are serious offenses and would fall in with the scheme that you have in the schedule under the Fingerprints Act. But I would also want to caution members that if you're going to make a recommendation, it can't be a recommendation to amend the Fingerprints Act. Remember that your remit is the Cybercrimes Act. And yes, I know there's always this discussion about consequential amendments, but I really do think that the better approach, and the precedent has been set in other committees, where what you would do is make a recommendation in your report that the relevant ministry consider the matter, and perhaps you can put some urgency to it. But the Ministry of Science, MSET, can actually approach MNS based on the discussion of this committee and make a recommendation to MNS for consideration to be given, which is why Ms. All would have then said the schedule could actually be amended even before you conclude your deliberations and even before you submit a report. So I'm just trying to tie in what Ms. Auld was saying as well.
So Chair, if I may ask Fulgen, the key to
One second, Senator Gale. Senator MP Robinson, were you finished?
I'm clear, and I'm supportive of exactly what the Solicitor General said, and I think we should proceed that way. So I'm clear.
Thank you. Thank you. Senator Gill?
So just for clarity to Soljan, the key to our committee is to be in a position to make the recommendation and have the recommendation recorded in our report.
Yes, you could do that, and it's suggested that you do that. But as Ms. Ald was trying to point out, MSEC could also approach the Ministry of National Security, who could take action even before you do.
Before, okay.
But yes, it is because you would have to, I would say, address it in your report because a recommendation was made. And normally, as a good committee, you wouldn't ignore the recommendation. You would make your recommendation. I'm just saying that I think this falls a little outside of your remit to actually recommend the amendment itself. I'm suggesting that based on the remit of this committee, what you would do is make a recommendation that the relevant ministry consider the matter. And the relevant ministry is the Ministry of National Security.
Right, understood, agreed with the approach. Thanks.
Thank you, Sovereign. And so I know the team will take note of that. I think the committee members are therefore supportive of an indication to be given to Ministry of National Security of the matters discussed in relation to the Fingerprints Act. And perhaps those discussions could be commenced or a preliminary indication given to them so that even we could get their feedback as to whether it's something they would be minded to do. I mean, sometimes you have those discussions and then you hear, well, no, actually we're overhauling this entire act. So it's not something likely to happen very quickly. But if perhaps CTD, some feedback could be given to us even before we get to the point of making the recommendation in the report, though I believe members are all agreed that the Solicitor General's recommendation and advice is what we would go with.
Chair, I believe, yes, we would be able to do that. The committee would recall that we have a number of things to discuss with various entities, to include the MNS, and so we'll raise that as one of the things to discuss. So we'll put that forward as a recommendation that has come.
Thank you. Okay, shall we continue? So just to tie up before we leave this matter, Member Robinson and Senator Campbell Rodriguez, Senator Gale, I believe, recorded their support for this proposal. We've discussed the method of effecting it. Are there any members with any objections to this proposal? And if not, then we'll move on to the next. Thank you, CTD.
Right. So, Chair, committee members, we'll now move to page 46 of the April 26, 2022 document. And we're going to be considering the recommendation from the Jamaica Bankers Association. The JBA notes that the Cybercrimes Act and the Law Reform Fraudulent Transactions Special Provisions Act overlap substantially in the criminal acts which are covered in that one criminal action may be an offense under both acts. So they have recommended, they also note that both acts include an obligation to review after a passage or a certain period of time. And they have recommended that both legislation be reviewed simultaneously. So we note that Section 20 of the Law Reform Fraudulent Transactions Special Provisions Act of 2013 makes provision for its review no later than 5 years after the commencement of the Act. And the Act, of course, having been promulgated in March 2013, is therefore past due for review. As this committee is aware, Section 25 of the Cybercrimes Act calls for review of same 3 years after the date of commencement, and therefore the review of both pieces of legislation should have been due or would have become due in 2018, with, of course, the Cybercrimes Act being considered now. So the MSEC notes the JBA's recommendation, and in the circumstances and following the line that the SG would have indicated the committee may wish to recommend that the ministry with responsibility for that piece of legislation engage the process for the review of same.
And the responsible ministry for the Law Reform, Fraudulent Transactions, Special Provisions Act is who? Is that Ministry of Justice?
I am not
Or
absolutely
is that
sure.
finance?
No, I doubt it would
SD,
be.
do you have a,
SG.
can you opine on that? Or anybody from the Parliamentary Council Office?
I believe it may be MNS, Chair.
MNS, okay. Thank you, CPC. Members, you've heard the proposal and MSET's position articulated by CTD. Any objections or indicate your support?
Chairman or
Yes,
Chair Lady.
Senator Longo, go ahead.
Hi, sorry, I'm having a connection issue where I'm at, and I heard mention, I joined in to hear recommendations by the JPA in Ms. Murray's input just now. Could you please just repeat for me what the proposal is so I'm clear as to what it is that the JPA was referred to? If it is my JPA, that's
So the JBA, no, not JPA, JBA, Jamaica Bankers Association.
Thank you.
So, right.
Okay, thank you. But well, I will look through to see if I can.
So just to fill in the gap you're having, the Bankers Association recommended that the provisions in the Law Reform and Cybercrimes Act the Cybercrimes Act and the Law Reform Fraudulent Transactions Special Provisions Act contain provisions for review of the Act. Both would have fallen in 2018. Cybercrimes is being reviewed, but fraudulent transactions is not yet being reviewed. And so the recommendation was for the process of review of the Fraudulent Transactions Act to be engaged, since both acts sort of work together and overlap in so many places in respect of the offenses that they capture. So a similar recommendation is being suggested that the relevant ministry be engaged to see if they will undertake this process.
Okay, well, yeah, I'm in agreement with that. Thank you.
So again, Chair, this is another area that would be cited in our report as another recommendation coming from the committee. Taking note of what the JBA has stated.
Right.
And what has been supported.
I would imagine so, Senator Gale, and indicating a similar recommendation as the one on the cyber.
We dealt with previously.
Right, cyberbullying, yes.
Right.
Okay. If there are no objections to that proposal, then we can move on to the next one, CTD.
Thank you, Chair. The next recommendation comes from the Ministry of Education, Youth and Information. Well, now the Ministry of Education and Youth. The proposal was that the Child Pornography Prevention Act be incorporated into the Cybercrimes Act. And we would have sought the Office of the Parliamentary Council's guidance on this recommendation. And so I will defer now to the CPC.
Thank you, CTD. So child pornography offenses, once they're committed using a computer, would already be covered by virtue of Section 4 of the Cybercrimes Act, which covers offenses using program or data held in a computer, where it's used to commit an offense under another act, where the offense attracts a penalty of more than 1 year. So the relevant offenses under the Child Pornography Act, Section 3, Section 4, and Section 5 all involve penalties over 1 year. So they would already be covered by Section 4 of the Cybercrimes Act. So in our view, there's no need for any further provision to include them.
CPC, I'm not sure I captured the last bit of what you're saying. You're saying there's no need to include them?
Right, they're already covered by virtue of Section 4 of the Cybercrimes Act, because they're all offenses where the penalty exceeds 1 year. So by virtue of that,
right,
they're punishable as cybercrimes, which is in addition to the penalties already set out in the cybercrimes, in the Child Pornography Act.
okay. Any comment, members? Okay, can I interpret silence of members as support for the position put forward by the Chief Parliamentary Council?
Yes, Madam Chair, for myself.
So we wouldn't do anything further with this then. Okay, I think we can move on. CTD Murray.
Moving chair committee members to page 48, another recommendation from the Ministry of Education and Youth, and this is in respect of the Sexual Offences Act. They recommended that we revise, or the committee considers revising Section 8 of the Sexual Offences Act or the Cybercrimes Act to include a provision akin to Section 63 of the Ghanaian Cybercrimes Act, and that section in Ghana's legislation treats with seducing, soliciting, luring, grooming, or enticing, and so on, a child. They also suggested that consideration should be given to reviewing Section 9 of the Sexual Offences Act to remove the requirement for an offender to meet or communicate with the child on 2 occasions prior. This matter was considered by the Legal Reform Department, so we defer to them in respect of their research findings and proposed recommendation.
Thank you.
Good afternoon, Chair.
Sorry, before you go ahead, can you just tell me what is the legal definition of a child in terms of age?
The member is asking what's the legal definition of a child by age?
Age.
It depends on the legislation that defines the word child, but generally it refers to persons under the age of 18.
Okay, thank you.
Okay, so the Ministry of Education and Youth, as CTD indicated, had made some recommendations for the committee to consider the amendment of another legislation, the Sexual Offences Act, which falls under the portfolio remit of the Ministry of Justice. Now, a joint select committee was appointed to consider the Sexual Offences Act, as well as other legislation, notably the Offences Against the Person Act, the Child Care and Protection Act, and the Domestic Violence Act. Recommendations were made to amend these sections that the ministry has highlighted. And in summary, some of the recommendations would include broadening the scope of the offense to refer to persons committing it instead of adults, as well as to make it technology neutral. So it would capture all the different ways in which the offense can be committed towards children. We would suggest, we are aware that the work is far advanced in giving effect to the decision of that Joint Select Committee meeting report in terms of amending the Sexual Offences Act. And so our recommendation is for the Ministry of Education and Youth to make contact with the Ministry of Justice regarding its proposals. And we commend that recommendation to the committee.
Can you restate that recommendation, please?
We are recommending that, having regard to the fact that the Ministry of Justice is advanced in terms of giving effect to the recommendations of the Joint Select Committee report to amend the Sexual Offences Act, that the committee could make contact with the Ministry of Education to advise that they submit their recommendations for amendment to that ministry. There could potentially be an issue of timing if the committee's report succeeds the actual tabling of the amendments to the Sexual Offences Act. And so we think in the circumstances, the opportunity should be taken by the Ministry of Education to make contact with the Ministry of Justice regarding sections 8 and 9.
Well, before we send the Ministry of Education off to make to consult with the ministry responsible for the Sexual Offences Act, are the committee members taking on board the proposal by the Ministry of Education? And the proposal as captured in the matrix on page 48, that the Section 8 of the Sexual Offences Act be revised to include something akin to Section 63 of the Ghanaian Cybercrimes Act regarding seducing, soliciting, luring, grooming, or enticing, or attempting to seduce, solicit, lure, groom, or entice a child or another person believed by the person to be a child for the purpose of facilitating, encouraging, offering, or soliciting unlawful sexual conduct of or with any child, or with the visual depiction of such conduct. That, as I understand it, is the proposal of the MOE. Is that supported by committee members? Go ahead, Senator Campbell-Rodriguez.
Yes, based on my understanding of what the JSC established to review the Sexual Offences Act, based on the recommendations that were made, I think what the ministry is asking for would be covered. And as such, I do support the idea that the Ministry of Education have that they be recommended to have that conversation ASAP with the Ministry of Justice, given that this is a time-sensitive matter. Sorry.
Sorry, thank you, I was muted. Okay, thank you, Senator Campbell-Rodriguez. Does anyone else have any comments on this?
Given the fact that I'm not clear in my own mind how this process works. So here we say we are recommending that the Ministry of Education be informed that the best route is to speak with the Ministry of Education, sorry, the Ministry of Justice, given what happened with the other joint select. Who does that and within what time frame? Because this is the second issue today that we're saying recommendations should be made to another place to have actions done. But who is responsible for doing that? I'm just not clear in my own mind as to the process.
So let me see if I can help with that, because what the advice we got from the SG earlier was that this would be a matter, if the committee is so minded to support the proposal, then it would be for the ministry's team and that would be science, energy, and technology, notwithstanding that it's a proposal of the Ministry of Education. If we are accepting that this is a proposal that we support, then we could ask the ministry to, and that MSET, to have the consultations with, I believe it's Justice, to see if that proposal could be considered in their ongoing review, which it seems has commenced and may be far advanced. CTD Murray, do you understand that to be the method and the path we would take?
Just before CTD Murray answers, I'm just asking because in a conversation a few weeks ago where it was discussed that meetings be held or discussions be held with certain ministries, the response from MSET was that they would just collate everything and wait until the end to have these discussions. I am sort of flagging this one and the one from earlier because of time sensitivity, especially for this particular one, because we're not sure in our own minds when this process will be finished, and the Ministry of Justice may have gone far ahead. So I'm just wondering if we can take this out of the loop for the sake of efficiency and just have it done.
But I think that's exactly the recommendation from Legal Reform Department, as I'm reading it, and as I think it was Mr. Basco was articulating it. But the question before anybody has any consultation, and it's a question that yet is unanswered, is, are the members in support of the recommendation coming from the Ministry of Education? Certainly the Ministry of Education can on their own have consultations with the Ministry of Justice. Nothing prohibits them from doing that. But in respect of the recommendation in the context of the Cybercrimes Act, are the members of this committee supporting the proposal that is being made by the Ministry of Education? Because at some point in our report, we have to opine one way or the other on it. So can I get some feedback from the committee in that regard, please? Am I to take it that the silence of the members means that they do support it? And so then all we have to work out is a mechanism of engagement with the Ministry of Justice, and further that the members will, that we will note in our report that the recommendation was for the relevant ministries to have consultations to effect this matter. Member Robinson, Minister Samuda, Senator Bunting, Senator Gale. That was a compound question, so I don't want to assume silence is agreement. Are members hearing me? I'm not sure.
I'm hearing you. I was just a little distracted at the question you were asking. My apologies.
Right.
You're asking for confirmation on the Ministry of Education's proposal?
Well, let me just repeat. The Ministry of Education has made this proposal. I'm asking if the members support the proposal they're making. And I'm making the point that the Ministry of Education is free to pursue this matter separate from this committee with the relevant ministry. But if we're going to opine on the proposal, it having been made to this committee in our report, do the members support what the Ministry of Education is proposing for discussion with the Ministry of Justice? And then I saw somebody, Legal Reform had their hand up. Did you want to say something?
Yes, Chair. We were just going to offer some additional considerations for the committee to considering in answering this question. The first is that we cannot say at this point that the exact wording that is used in Section 63 of the Ghanaian Cybercrimes Act, the terms that are used, we are not sure at this point whether all those terms are acknowledged in our Sexual Offences Act, or whether the offense itself of grooming considers all of these actions. The other thing we would suggest, Chair, is that we have not seen where in the report it was discussed the rationale for the requirement for an offender to beat or communicate with the child on 2 occasions. So we're not in a position to offer an opinion regarding the feasibility of the removal. So we would commend some degree of caution in entertaining the ministry's proposal, because these issues would have been the subject of extensive deliberations during that Joint Select Committee's review. And so if the committee is minded, there are 2 options which we think are available. The committee could not accept the recommendations with a view to recommending that the ministry engage the Ministry of Justice for the reasons that we have provided in terms of the report. Or the other alternative we think would be to perhaps indicate that the committee is not in a position to give effect to these recommendations, having regards to the terms of reference of the committee for the establishment of this committee.
Okay, the members heard Mr. Bascom's recommendation as to how we could deal with this. I am personally minded to agree your recommendation, Mr. Basco, and other members can opine, because just looking at Section 8 of the Sexual Offences Act, you know, it certainly does not have it's the actions that would fall under this offense are a lot more in this proposal than currently existing. I suspect that would take some amount of policy consultation and deliberation. It's not just a matter of a simple amendment. So I am in support of not accepting the recommendation, but asking for the relevant ministry to have the discussions outside of this committee. That was your recommendation outcome. Yes, Mr. Basco?
Yes, Chair, that's correct.
Okay. I'm in support of that. Can the other members opine, please? Senator Campbell Rodriguez, are you okay with that?
I am okay with that, Madam Chair, but I'm still just want us to not let this fall through the cracks. So I'm still, the second part of my issue, I'd still like for us to get some clarity.
Okay. So ultimately we're still asking that it be looked at, and so CTD Murray, that I think would involve the perhaps you having some discussions and leading that charge for the Ministry of Education to put this forward in those several discussions that you're going to have, and then the committee will fall where it falls in its report on this.
Right. So we'll do one better than that, Chairman. We will have the conversation with them immediately, just to signal that the matter was discussed today, and that is the proposed course of action, and so that they can be advised immediately to move ahead with their proposal.
Okay, thank you so much.
CTD Murray, Madam Chair, my heart
Yes,
is singing a very nice tune to hear from CD, from Miss Murray, that this will be action today. But Madam Chair, can we just ask as a little sideline that all these items that we're asking to be actionable, if they can just go on the action sheet that we said would start going out with minutes and to the technical team, just as a reminder.
Okay, thank you. So the action sheet that comes out of that ought to be produced with the minutes can reflect these.
And
To do
shared with
now
us with the
matters.
minutes, yes, as well as with the technical team.
Yeah. Okay. Thank you. Okay. I think we are settled on the direction in relation to this recommendation, and if that is so, and there are no objections to moving on, CTD Murray.
Chair, committee members, the final matter for consideration on this matrix is that of a recommendation from the Financial Services Commission. They thought it would be useful for other pieces of legislation that may be affected by the Cybercrimes Act to be referenced in the Act, given the fact that much criminal activity now takes place virtually. The Office of the Parliamentary Counsel was asked to opine on this, and so I would defer to the CPC to comment.
Thank you. So again, Section 4 of the Act provides the necessary cross-reference because it references all offenses where the penalty exceeds 1 year, as long as the offense is committed in using a computer. It's not practicable to refer to each law by name because it's quite a lot, and also the provision also takes into account laws that might be enacted in the future. Once the penalty exceeds 1 year, they will be covered by Section 4. So we think that the concern of FSC is already addressed by virtue of Section 4 of the Act.
Thank you, CPC. So members, for this, the advice is that this not be a recommendation, that you reject this recommendation of the FSC. Are members in agreement?
Madam Chair, if no one else has anything else to say, I just want to make a comment on that.
Sure, go ahead.
Just to say that I'm in agreement. However, the fact that so many different entities have come forward and we have made the point that Section 4 will cover it, it means then that they're not reading the law, the bill properly. And I would like to suggest that all the entities where we have seen that happen, that they be written to and this explained. And the reason I'm making that suggestion is the Cybercrimes Act of 2015 was a piece of legislation that was extremely useful, but persons have complained that it is difficult to use. And I'm talking about the DPP's office, I'm talking about MOCA, I'm talking about the Financial Services Commission, all of these, the Bankers Association, it's been a consistent theme that it's difficult to prosecute under. But when you listen to the technical team and to the solicitors, General's Department and LTD, etc., LRD, you realize that it's also misunderstanding and not understanding. So I think we would help if we really want the legislation to become useful. Maybe a letter be drafted, I'm not sure by whom, and sent to all these entities that gave recommendations to us, especially those that we point them back to Section 4, just explaining and providing an understanding. I think it would help the process. It's not just about making the law, it's about ensuring that everyone understands how to use it.
Okay, thank you. Right.
Here,
Yes, Senator.
we're dealing with a legislation that is going to require constant review to treat with the times that we are operating with, the types of criminals that we are operating with. And when I listen to those who are the enforcers and the businesses who would have been impacted by cybercrime, it seems to me that they want to have a confidence in a legislation that really works, that really captures the culprits. And that's the type of confidence that this piece of legislation should inspire. It is a legislation that we're going to, there's a review period, but outside of the reviewing of the legislation, the activities that takes place that allows the legislation to work has to be improved. And this is what I believe these institutions have been clamoring for, and looking for us as lawmakers as part of the review to lend support in that direction. And so, you know, it's challenging, but we have to consider it as work in progress. And if and when we implement the new changes, we have to ensure the powers that be, those who are the actors and the players, our enforcers, have to ensure that this thing works to inspire confidence of those who came to the Joint Select Committee expressing their concerns.
Okay, thank you, Senator Gale. Are there any members who wish to make any comments, other comments before we move on? If not, CT Murray, it seems we have come to the end. Sorry, go ahead, Mr. Basco.
I think we were discussing and in support of what the members had said. What we noticed in our research in other jurisdictions is that the ministries and the stakeholders who play a role in the cybercrimes regime, they tend to prepare explanatory notes or frequently asked questions, and they're publicly available. So perhaps some consideration could be given to the extent that the act has been used and there's some certainty surrounding the interpretation of the provisions. For that to be accessible to the public, it might help the public to be more comfortable in understanding the aims and objectives of the law. So we are suggesting, therefore, that as a sort of soft recommendation, and I use the term loosely, that consideration be given to the creation of a document to explain you know, the intention or the operation of the law. Because we also have seen in Jamaica where there are videos prepared by government which shows the practical application of the Cybercrimes Act. And we're not sure whether that has also been considered by stakeholders who are presented. And that presentation would have been done by the DPP and the JCF.
Okay, thank you for that. And that sounds like an initiative that that MSET should jump on, given the comments of both Senators Gale and Campbell Rodriguez and Mr. Basco. And I suspect Mr. Basco LRD will lend its support accordingly. All right, CTD Murray. I think we have come to the end of part one of the matrix, if we're calling April 26th document by that name. And if so, then we move now into the direction of, I believe part two was circulated. Are we moving straight into part two?
Yes, Chair.
Yes,
part
okay.
two was shared. Yes.
Okay. Do all the members have a copy of part two?
That's the one that was recently shared.
Yes. And so that, hold on. I thought I had a copy. Now it's looking like I don't. Part two. Okay, I'm sorry. I had the wrong one downloaded. Okay, CTD Murray, go ahead when you're ready, please.
Thank you, Chair, committee members. So that's the matrix dated July 25th, 2022, and should be titled Matrix Cybercrimes Act, General Recommendations, Part 2, July 2022. The first matter for consideration on the matrix, Chairman and committee members, is another recommendation from the Ministry of Education and Youth regarding the aiding and abetting of child dealing for the purposes of sexual abuse. Again, they refer to Ghana's Cybercrimes Act, Section 64, which provides that an owner or operator of a computer, online service, weblog, internet service, or internet bulletin board service shall not aid and abet another person for the purpose of facilitating or encouraging the online solicitation of a child, or permit any person to use the service of that person for the purpose of facilitating, encouraging, offering, or soliciting unlawful sexual conduct of or with a child, or the visual depiction of such conduct. They note that the provision in our jurisdiction that is similar to Section 64 of Ghana's Act is Section 9(2) of the Sexual Offences Act, which states that an adult commits an offense if he or she causes another person to carry out the offense specified in subsection 1. And subsection 1 in this instance would be sexual grooming of a child. So they conclude that it would be useful to amend Section 9 of the Sexual Offences Act to include the same level of specificity as Section 64 of Ghana's Cybercrimes Act. And I know the committee would have just had its deliberation on the Sexual Offences Act, but I would still defer chair and committee members to the LRD in respect of this.
I'm sorry, before you start, Mr. Basco, Section 9(2) of the Sexual Offences Act. Can you just read Section 9(2) for us?
Sure, Chair. Section 9(2) of the Sexual Offences Act provides that an adult commits an offense if he or she causes another person to carry out the offense specified in subsection 1. So what the ministry really would be referring to is Section 9(1) of the Sexual Offences Act, because it details the activities or the manner in which the grooming offense is carried out. May I proceed, Chair?
Yeah, you can proceed. I don't know if I'm understanding the connection between Section 64 and Section 9.
Well, I think what it is, Chair, having looked at Section 64, Section 64 is an amalgam of the provisions in our Child Pornography Prevention Act, as well as the Sexual Offences Act, to the extent that it refers to facilitating grooming or to facilitate engagement in child pornography. That's my understanding of Section 64. We have the same reservations as we raised in the earlier comments on Section 9. And we do think that, again, the committee could decline to accept this recommendation with a view to instructing the ministry to engage the Ministry of Justice regarding the enlarging of the Section 9 offense. But in addition, Chair, based on the elements of the Section 64 offense, what we're realizing internationally is that there's a trend towards regulating online content providers, internet service providers, so that they play a more proactive role in terms of monitoring what is uploaded on their systems and providing opportunities to have persons remove that content where it's been uploaded. So from our reading of Section 64, we still aren't convinced as yet in terms of how practically it has operated and how the courts have interpreted it. And so we think what the Joint Select Committee recommended in its review of Section 9 is an adequate safeguard in terms of broadening the means of communication with children and broadening the scope of the offense to include persons. But if the view is that Jamaica should move towards the sort of regulation of online service providers and social media, etc., that a discussion would need to be had with the Ministry of Science, Energy and Technology, because we think that the Telecommunications Act might be impacted, as well as the Ministry of Justice.
Thank you, Mr. Basco. Committee members? This matter falls as some of the other recommendations that the Ministry of Education has made, that we're really not perhaps the proper place to deal with this. So do members have any objections to the advice being given by Mr. Basco, adopted as our recommendation?
Madam Chair, I'm in support of the recommendation, and maybe what we can do, because there are quite a few things that have happened today or in the last meetings where we have made recommendations of other pieces of legislation that we're recommending for them to be for changes to occur to impact on this piece of legislation. Can we ask that a list of that be prepared for us, just so we don't lose sight of it? Is that possible?
I'm sure that's possible, and I think that it's not a difficult matter, because I know CTD Murray was keeping track of some of these that would require further consultation outside the realm of this committee. So CTD Murray, could that list be shared with the committee members, please? And this being one of those that would fall within that list.
Chair, we've been taking our cue as well from the clerk to the committee, who has provided actually the committee a list of all the things that it has deliberated on and those things that remain outstanding. But we'll also look at the list, and we can work through that alongside the clerk to ensure that that list is comprehensive and captures everything. But we are taking notes, so we will treat with those matters specifically related to the MOEYI and those that impact the Sexual Offences Act, and we'll just communicate with them in respect of all of those recommendations that relate to that piece of legislation.
Yes. Okay, thank you. You have the floor.
So chair and committee members, that would take us now then to page 3. And this is a recommendation from the matrix, and this is a recommendation from MOCA in respect of skimmers and card readers. So MOCA has recommended that the possession of skimmers or card readers, magnetic strip cards rather, extracted credit cards, contents, as well as point of sale devices without lawful excuse be criminalized. The MOCA acknowledges that Section 10 of the Cybercrimes Act, as well as Section 8 of the Law Reform Fraudulent Transactions Special Provisions Act, better known as the Lotto Scam Act, could treat with some of these devices, but it believes that both pieces of legislation contain a limitation in that the criminalizing of, or in that the possession of these devices are linked to the context in which the individual has it with a view to committing or facilitating the commission of an offense. They've opined that given the utilization of these devices in the cloning of debit and credit cards, they're of the view that law enforcement should not be obliged to have to prove the possession of such items in the context of the commission or intended commission of other offenses. And so consequently, the mere possession of such devices should be criminalized. So with respect to our research, and this is something that we would have pointed out to the committee before, that Section 10 of our Cybercrimes Act, in our minds, generally seek to implement Article 6 of the Cybercrime Convention, which, among other things, criminalizes the possession of a device and or a computer, password, access code, etc., with the intent that it be used for the purpose of committing any of the offenses established in the convention. We would have previously shared with the committee as well that the drafters of the convention had to contend with how to treat with devices that could serve a dual purpose. And in order to avoid the danger of overcriminalization, where these devices and tools are concerned, the language as crafted now in the convention is what was agreed. So, for example, those tools that are created for the authorized testing or the protection of a computer system could easily also be used in a destructive way. And so, they're serving two purposes: a good purpose and a bad purpose, positive or negative purpose. And so, in that context, the convention itself would have the language as used would have been that these devices are within an individual's possession with a view to or with an intention to commit or facilitate the commission of an offense. So research conducted, we would have reached out to the LRD for some support on this particular recommendation, and the LRD in its research found a report that coming out of the Office of the Director of Public Prosecution, which provided advice in respect of how to interpret Section 8 of the then Cybercrimes Act of 2010. And just for the committee members to note that the Section 8 of the Cybercrimes Act in 2010 is a similar provision to the Section 10 currently in the Cybercrimes Act of 2015. And so it is believed that the interpretation that the Director of Public Prosecutions would have given in relation to the then 10 Section 8 provision would apply to the Section 10 of 2015. So the DPP, in its report on effective investigation and prosecutions of lottery scams in Jamaica, opined that on the face of it, Section 10, I'm going to use Section 10, may be used to prosecute alleged offenders, that is lottery scammers, in instances where they take steps preparatory to the commission of an offense or to facilitate the commission of an offense under the Act. The DPP noted, for example, that in instances where the alleged scammer is found in possession of a skimmer or card reader or other electronic devices designed or adapted primarily for committing an offense under the Cybercrimes Act, the suspect may be successfully prosecuted under Section 10 of the Act. So the LRD is of the view, and we share the view with them, that the advice of the DPP, as expressed in its report, would operate to address the concern raised by MOCA, as Section 10 of the Act may be used to prosecute alleged offenders who are found in possession of a skimmer or card readers or other electronic devices in instances where they take these steps preparatory to the commission of an offense under Sections 3 to 9, or to facilitate the commission of these offenses. And so so that would have been in relation to our research finding. In looking at the comments though, or the recommendation from MOCA, it appeared to us that there might be two distinct recommendations that were being made. On the one hand, the MOCA made the point that the possession of skimmers or card readers, etc., should be criminalized where there is no lawful excuse for possession. And then by the end of the recommendation, they recommended that the mere possession of the skimmers or card readers should be criminalized. That latter recommendation seemed to us to be falling within the ambit of what we would consider a strict liability offense, in that the mere possession of the thing without more would make you criminally liable.
CTD, can I ask you just to restate the distinction for me? So in one breath, it's a mere possession that they want criminalized, but in the other breath, it's possession
without lawful excuse.
Without lawful excuse. Okay.
So one seeming to give a defense and the other one seeming to be without.
Yes. So,
yes.
So can I ask you, for, and this might have been discussed at the time some of these presentations were made. What other reasons than those which fall within these types of offenses would a person have for possessing a skimmer or card reader? What are they used for otherwise?
I would defer to Lieutenant Colonel on that, but what we have been made to understand is that there are legitimate uses for these things. So for example, a bank could legitimately use it for whatever reason, or some organizations can be legitimately using it for their internal purposes. And I will stop there so that Lieutenant Colonel can assist me with this. But the general point is that there are instances in which some of these devices serve a dual purpose. But I will pause and allow Lieutenant Colonel to answer that question.
Thank you. Thank you. Lieutenant Colonel Sterling, welcome and thank you.
Afternoon, Chair, afternoon, members. The point at which CTD Murray stopped is really where the nexus of it is. So whilst we're used to these pieces of equipment being primarily in financial institutions or institutions that are licensed in most cases to provide magnetic striped cards or chipped cards, there are security researchers, lecturers, and other persons who provide services sometimes to the banks themselves. In the discharge of their duties, they can sometimes lawfully be in possession of these items. And so this is where the distinction that is apparent in the way the MOCA recommendation is framed suggests that there are two separate requirements or requests that are being made in the same paragraph. Now, in the first instance, it would be one that is more readily accepted, that if you can justify lawfully why you're in possession of these paraphernalia, then you ought not to be held criminally liable. Whereas in the second, it is suggesting that irrespective of whether or not you're lawfully in possession of it, at the point at which you're found in possession, you're criminally liable. And so when we look at it, if we rule out the security researchers, the lecturers in computer security, data security, etc., then it would leave only the banks. The fact is, though, that persons who are legally allowed to be in possession of these things for teaching purposes, for demonstration purposes, for repair and the provision of services to financial institutions would find themselves on the wrong side of the law if the second interpretation of what is in the recommendation by MOCA would be what is supported and brought forward.
Colonel Sterling, can I ask you, is there any requirement to, are these things just bought in a retail store somewhere, or are these things that you need some sort of special permit to import? Can I go into a store and find one and buy one?
If you expand the definition of a store to include the dark and deep webs, yes, you can. If you're restricting the definition of a store to a physical legal entity where the rule of law determines that certain items are restricted and can only be accessed by certain persons who can demonstrate the need to purchase, similar to narcotics or other drugs, then the answer is no. The fact is that persons can, if they know where to look, procure these items in the same way that persons can buy illegal firearms, etc. And once they have it, the difficulty then is to determine or to disaggregate who is legally supposed to be in possession of and who is not. And so the access to them is not something that is really restricted or regulated once you have access to the dark web. No, ma'am.
Okay, so let me try and see if I can wrap my brain around it. If I could ask you to just dive a little simpler for me. Are you saying then that if I am caught at the port coming into Norman Manley Airport with this in my suitcase, that I would either have the item confiscated or I could face arrest? Is it a restricted item? Is it an item that I need a license for, a permit for? What pertains in our jurisdiction now?
The actual customs restrictions is not something I am aware of or au fait with. And so that would be something that could be further researched to see whether or not they're restricted items. Certainly the use of them in Jamaica is considered restricted and in some cases illegal.
And where is it considered restricted or illegal?
Within the Law Reform Fraudulent Transactions Act, the mere possession of them and the use of them to create cloned cards and or fraudulent cards is what would make the possession of and the intent and actual use of them in that endeavor illegal.
So in the Law Reform Act, you're saying that the possession is an offense if the possession is in furtherance of the use to create these fraudulent cards, but
right,
not possession simpliciter.
No, ma'am.
Okay, and I'm sorry, who is it that was proposing this? Was it JBA?
I think it was
Mocha.
Sorry, Mocha. And so Mocha's proposal then is for us to make possession an offense without possession linked to the commission of another crime.
Chair, if I might,
the two, yes, please.
Just pause 1 second, because we recognize that there seem to be conflicting recommendations in respect of MOCA. We did speak to MOCA about it, and what they indicate, and yes, so what they indicated in our discussion was that the intention was to recommend the former, which is possession without lawful excuse. So that would put the mere possession recommendation to bed. So the focus now would be on their first recommendation that the possession of it is without lawful excuse.
Except CTD Murray, if the item is not generally an illegal item, then what requirement is there in law? How do we craft a provision here asking for the offense of possession without lawful excuse to be an offense if we're not required to have an excuse to have it in the first place? Is it a restricted item or it's not a restricted item? And if it's a restricted item, which law would make it a restricted item? The Customs Act, this Act, the Fraudulent Transactions Act? A little bit more than what I think we can do in cybercrime. So I'm really wanting us to drill down into that recommendation.
And, we take your point, member, that we really would have to consider what the law, if we're talking about it from what would be lawful excuse, but I just want to point out to the committee and then remind the committee of an amendment that we had proposed to Section 10. And the amendment we had proposed to Section 10 would have it readings, of course, subject to amendments by the drafters and the consideration of the drafters. Reading: an offense is committed if a person without lawful justification intentionally possesses these devices. When we discussed the matter with the Legal Reform Department, they shared exactly the same concern that you have, Chair, that they couldn't find any law that existing which says that you can have or not have these devices. And so there was a recommendation that they proposed that would not look, which would have us not use the language lawful justification or legal excuse, but rather without reasonable excuse. It was thought that that would be that is broad enough to include lawful justification if there is one, and if we can find it, and could also address situation where there is no law permitting the manufacturing, etc., or possession of it. So the language would be not.
But CTD, I don't know that you cover the concern that I'm expressing that you say LRD shares, because I mean, let's talk about a cricket bat, for example. Right now I can go and get a cricket bat somewhere, right? And if we say a cricket bat wasn't to be had in Jamaica and I get it somewhere else, then I bring it in. You can't stop me at the port for having a cricket bat. A cricket bat, there's nothing illegal about having a cricket bat. So unless you're gonna make having this reader illegal, I mean, you'd first have to start from the point where the thing is illegal in the first place. And so nobody can have it. And then you talk about, well, maybe it's not completely illegal, but there are restrictions on who can have it. Because just talking about without reasonable excuse, I'm not required to have an excuse to have it, unless you make that a part of the provision. So help me with that.
Which is exactly where the MOCA recommendation tweaked is going, that there would now be an offense that say that you need to have a reasonable excuse to have these devices in your possession. And if you can't, when stopped and when found with these devices in your possession, provide a reasonable excuse, and that is a basis for law enforcement officers to charge you under the Cybercrimes Act. So that is the consideration. But just to remind the committee members that this present scheme in the legislation under Section 10 is one that says if you have these devices and your intention is to commit or to facilitate the commission of any of the offenses in the Cybercrimes Act, then that is a basis for which, well, that is an offense in and of itself, and you can be charged on that ground.
Who determines intention?
The court.
The court. So you're going to be charged.
Right. So all of that is evidentiary.
Amount of defense.
Mm-hmm.
And you would have had to demonstrate.
Unwieldy.
You would have had to demonstrate the intent in the first case.
Yes. But Senator Gale, you'll appreciate that when you're in court and a prosecutor has to mount a case on the basis of your intent, that there are lots of holes and gaps that can prevent that prosecution from successfully putting forward a case of intent.
Let me ask, for example, under the
go ahead, Member Wilson.
The lot, what we call the Lotto Scamming Act. If you're caught with a lead sheet right now, I believe well, I need clarification. Is that an offense by itself, or if you are caught with other things and the evidence is there that you are committing scamming, which one is the offense? I'm just asking for clarification. I think maybe Solicitor General or Legal Reform can help me with that.
So, Julian, you are making the distinction between the possession of and carrying out the action.
Yes.
Okay, before I ask Solicitor General to opine on that, can I just ask CPC if he had a contribution to make on this particular point? On this discussion? CPC?
Yes, thank you, Chair. Well, I had my hand up merely to indicate
I'm sorry, I didn't see it earlier.
Oh, okay. Well, I think that proposed wording introducing this concept of reasonable excuse is not really compatible with what is in the section now, because the section speaks about possessing, etc., the device for the purpose of committing or facilitating the commission of an offense. So there can't really be a reasonable excuse for that if your intent is to commit the offense or facilitate the commission of an offense. It's not compatible. So if you're going to introduce a concept of reasonable excuse, that part about having to prove the intent of committing or facilitating the commission of an offense would have to go. So you'd be left with having to show that you have a reasonable excuse for possessing the item, which, as you pointed out, and I agree, once the item itself is not illegal per se, then again, that concept of reasonable excuse, really, there's no real room for that. I think there's an additional element in the provision there, which also requires showing that the device was designed or adapted primarily for the purpose of committing the offense. Now, I'm not sure if that's part of the difficulty with the provision, that there's this dual hurdle that needs to be overcome. And so maybe the committee could look at removing that element of it, of having to show that it's designed or adapted primarily for the purpose of committing the offense. That would leave the prosecution with that hurdle of having to show that their intent was to commit or
Mm-hmm. Thank you very much. I had also seen Colonel Sterling's hand up. Did you want to say something, sir?
Ma'am, it was just that a quick look at the restricted items brochure from the Jamaica Customs Agency shows the credit card scanner requiring permission from the Ministry of National Security for importation, but the skimmer itself and other associated paraphernalia are not listed.
So perhaps it is then that a starting point needs to be seeking, having some consultations to place these items under a restricted list, I suppose with customs, or requiring that a similar requiring a similar authorization to bring them in, which would then mean that someone found with them here would have to demonstrate how they have them or why they have them. Then a sort of reasonable excuse type of provision would make sense. But CTD did indicate too that another hurdle in this provision is the question of the item being designed or manufactured. I don't have the language right in front of me. But CTD, can you just repeat that part of it?
Can I just ask a question? In a scenario, and I don't know if it would fall into this, where financial institutions employ consultants to do testing of their systems, and by doing some of these testing, the consultants would have to behave as if they are trying to hack in or trying to get access to. Now, if I'm in the business of providing these types of services, and I may need to acquire this type of equipment, where does that lead?
presumably, remember, you would have you would be required to get permission in a similar way that Colonel Sterling was suggested that these restricted items require that authorization from MNS. But I'll ask. I don't know if CPC or SG would like to opine on that, or CTD Murray. Or any member of the technical team who can respond to the member's question.
If I may, Chair, the Member Robinson, this is the gray area I spoke to in my opening comments, where if you are in that profession where you are considered a security researcher or consultant, the legal requirements for you to have some of the tools of your trade as far as cyber is concerned is not very clear. And so to move towards criminal offense for possession simpliciter is something that really is pushing the envelope of that understanding legally. Given also that there is oftentimes not specific requirements within the JCA guidelines or act, as well as with the MNS guidelines, there are cases where some of these items are readily procurable overseas. And once you get to customs, depending on whether or not you're able to get through customs with them, you are able to have them in your possession without the need for a license or any special permission. The question now is, once you have them in your possession, do you need to prove intent with respect to the commission of a crime or the maluse of these items, or is it that once you have them, you have a problem? And it's not just with the physical items. We're talking also about certain pieces of software used for penetration testing or hacking outright. But within the ambit of what you're doing, can you justify having them even though you did not get special leave to bring them into the country or to procure them in any way, shape, or form?
I hear you, Lieutenant Colonel. It's still though, I understand what you have said, but where does that leave us in this particular case? Because you are correct. I mean, it can be software. Every major financial institution would have penetration testing done by some company on their behalf and other things like that. I'm a little wary of including the possession as an offense.
And you still can have that special leave to acquire and utilize it for the purposes to which it was never intended. So there are many gray areas to this.
Mm-hmm.
I support the idea of having some restrictions in terms of acquiring through maybe the listed areas of customs, just to be sure and to be clear that, you know, you're preventing the acquiring of such items, like you don't utilize your Amazon account to acquire it. But there are some restrictions to which you have to pursue to legally obtain it. But I understand the gray area and how complex it can be.
Senator Gale, you want a restriction at the border, but what happens if I access one of these devices right here in Jamaica? So it has come in underground, and I have bought it off a man and I now have it, you're okay. You're not, well, let me not say you're okay. You're not comfortable putting that into the realm of an offense, my possession of it.
You see, in this case, your possession of it you would not have reasonable excuse because you're not in a legitimate business to be utilizing this equipment.
Okay, so you're saying it in the context of reasonable excuse. You want, in addition to the provision with reasonable excuse, you want there to be a restriction at the port.
You would first have to have a safeguard in terms of acquiring. And that safeguard in the first instance would come from the restriction through the ports with these listed items. Because that's the first point of entry.
Right.
And then after that, we deal with the possession and the use of.
Okay. Let me just canvass the room and see, are there members who have any other thoughts not yet expressed on this issue? Or any additional thoughts? Okay, so what I think I'm going to do is CTD Murray. This one has taken a little bit of time, but it is not a simple one. So can I ask you, in consultation with your other technical team partners, to take a look at this for the purpose of giving us a little bit more to enable us to make a decision on this recommendation? And I think you heard, and I think you're clear on the difficulty we're having in relation to the possession issue, possession simpliciter, and the strict liability question, etc., etc., and how these items are treated generally in our jurisdiction. What restrictions, if any, are put on them, which ones are restricted and which are not. If you and the team could give us some further guidance on that on the next occasion, then what I would ask is that members, if we can defer a decision on this recommendation to that meeting to give the team some time to do that necessary work. I think it would be more useful to us in that way.
The final point I just make on that is the potential for abuse when you have laws like this, where if a member of the security force doesn't like you or has an issue with you, and even if there is no intent, then the use of possession becomes an opportunity to detain you, arrest you, and then you're left with the situation of getting legal representation to defend yourself.
Noted, Member Robinson, and I think CTD Murray has taken note of that as well. All right, committee members, on that note, I am going to propose that we wrap up for today, it being 4:15, and we can note the point at which we have gotten to in the part, we call this the part 3 of the matrix, CTD.
Part 2, Chair.
Part 2, okay. So we would be at what page? Just note the page for the record for me now, please.
So we're at well, I'm assuming when the committee reconvenes or has its next meeting, visiting this skimmer card reader. My apologies, matter. So
right, we started at page 3.
Right.
Right. Okay. So if we can note that, and then we'll kick off with your report on that at the next meeting, and then move on through the rest of the matrix. And just to recap, there are the action items, if we're calling it that, in relation to the various consultations to be had on the provisions that really don't sort of, the recommendations that don't sit within the remit of this committee. If a list could just be provided to the committee members so that we too can keep track of of the matters that had been proposed to us, but which we're not taking a position on right now. And CTD Moore, you can update us on the next occasion in relation to the consultations that the ministry will have, or at least indicate to us that those matters have been communicated to the relevant ministries in relation to amendments to other acts that have been recommended to this committee. I think that covers all of the action items for today's meeting. I haven't left out any. Ms. Brandon, catch me up if I'm falling. I see Minister
No, you
Vaz.
haven't.
Thank you
Minister
very
Vaz
much.
back.
I got the last part of it. Thank you very much, Member Golden, for deputizing for me. Maybe I think I might have to make you do this more often. Using your legal skills and background. Thanks very much to the members for their attendance today. All right, so the next meeting is scheduled for September what, Ms. Brandon?
So it is being proposed that the committee meet on the 14th of September and the 28th at 2 p.m. So both days are on a Wednesday.
All right. Members, can you note those dates for me, please?
Minister, can Ms. Brandon just repeat them? I was breaking up. I wasn't hearing her so well, or she was breaking up.
That's September the 14th and the 28th at 2 p.m.
Both days at 2 p.m.
That's correct. Both days at 2 p.m.
Okay, thank you.
All right, thanks again, Member Golden, for chairing.
My pleasure, Minister.
Have a nice break, members. Get some rest and be safe. See you in September, God's willing.
Thank you. Have a good afternoon.
Come out and join us! Jamaica's 60 Independence Float and Street Parade as we dance through the streets of Kingston. See the half-mile spectacle on wheels. Starting at Randy Williams on Hope Road, onto Halfway Tree Road, Oxford Road, en route to the National Stadium. The Jamaica 60 Independence Float and Street Parade, Emancipation Day, August 1. Join the dancing through the streets from 10 a.m. or catch us live on TVJ and PBCJ.
When I look at how Jamaicans have excelled, it creates a certain pride in me. We have created some great Jamaicans in all fields. We have been doing something that's right. There is much that we have in Jamaica to celebrate.
It's Jamaica's Diamond Jubilee, celebrating 60 years of independence. Jamaica Festival Queen, Jamaica Gospel Star, Jamaica Festival Song, Independence Float Parade, Independence Street Dances, Grand Gala, and a whole lot more. Check the press for details and join us for the excitement, or watch it live on TVJ and PBCJ.
This is the land of my birth. Warning, 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 warning to the world. Warning, warning, warning. Climate change is happening. We got to
In 2009, several artists came together to warn us that climate change is real and to demand we take action. Climate action.
Summers are hotter than they used to be. Stronger hurricanes more frequently. You see?
13 years later, artists are looking back at the message, the climate action mission, and the role artists can play in today's fight against climate change. Grub Cooper helped produce the iconic climate change song Global Warning, written by Lovindare.
Mr. Grub Cooper, take us back to 2009 and the Global Warning song. Tell us the story. How did you get involved? Why was it necessary to conceptualize this song in the first place?
Indy Lafayette approached me, Lovindare, and some other musicians who, quote unquote, were fairly influential writers in the music business. And she introduced me in a closer way than, so to speak, to the whole business of climate change. So she said a good vehicle to market this whole climate change phenomenon would have been through music. Obviously, I immediately agreed with her because I know that nothing communicates to human beings like music does. The spoken word is fine, you know, even the politicians run to the music thing because spoken words is made on a platform or maybe on a media come in one broadcast. That's saying that when you put it to music and, you know, words and music and a beat and whatever, video go together, it's a coming together of many facets of the arts, and so you can't beat that. So the idea was, let us create a song. And we had meetings and everybody was sensitized. I elected to, I say, let Lovindare be the one to spearhead the writing of the song. And so it came about. So I wrote the song, I arranged it, got many artists to take part, and they were very, very enthusiastic because so good was the whole program that the artists bought into this thing because they understood what Indy was saying and the importance of dealing with the climate change issues. It's now on the front burner, it's not the back burner thing no more. And the video is as relevant today as it was 13 years ago.
I just get a call from, it was you here on our Indy. Yeah, I got a call and Rasta Rebellion, we are doing this project and we would like for you to be on board. Well, climate change, we all know that's something that have to do with life. So it's a yes for me. So I was on board from then.
So it was a no-brainer for me to be involved in the climate change thing. It's no sweat at all. And to this day, it's all there. And if I was called upon to do a song in the morning, I would do it because it's that important to mankind. You know, and I am one musician or entertainer. I want to be on the right side of history.
As the primary actor for climate change in the UN system, the United Nations Development Program was asked to contribute funding to the production of a song and music video called Global Warning, spearheaded by Panos Caribbean, and we also funded the climate change education training for participating artists back in 2009. Although produced 13 years ago, the song still resonates with us today with its infectious rhythm and powerful message.
I think the Voices for Climate Change Education Project has so much passion, so much enthusiasm, so much commitment on the part of the artists, and this has been from the start because remember, it is not a paid program. We've never had money to be able to pay the artists. What we've done, when we've had funds, we would provide a small stipend and we would cover costs like transportation and food and so on. So the fact that we've had at our highest point, we had 35 artists who were integrally involved in the project, you know, being out there spreading the messages both in Jamaica and regionally and internationally, and they've never really been paid. I think that is tremendous, and I'm so thankful for that goodwill.
So the primary strength of the video is simple communication about climate change and the role that each of us as Jamaicans have to play. So the rhythm is another thing that's very infectious, right? Because the rhythm is very good. You can enjoy it while listening to the music and memorizing the words.
Climate change is happening. Watch this, they're burning the garbage everywhere.
The groundbreaking global warning song and music video inspired another generation of climate advocates.
I get involved through the voice that I had. I sang a song for James Bond Beach here. Let's beautify Jamaica. Let's beautify Jamaica. Let's start with the beach. A clean environment that we seek. Because me don't want to see me in the sea and the garbage that swim with me now. So beautify our country. Clean up the beach. They led me to Voice for Climate Change from Aine. Aine led me to Aaron Silk as a warrior for Voice for Climate Change. He said me fit that purpose, so he sent me on. It was a concern for how we treat the beach, and I was the artist, them say, who fit, they bring that message across. So they came to me and tell me that I must write a song for the beach cleaning up. So when I come down by the beach, I see all of the problems we're facing our environment. Good coral, we fish them, you understand what I say? So I write the song.
Whatever affects the environment and affects us as people everywhere affects me too. And my generation coming up. So naturally, I would be interested in taking part in anything that I see is very conscious and good to take part in. I'm a poet, so I did do 2 pieces of poetry. One of them was, it's time to stand up and take a stance and stand up. It's time to wise up and overstand and stand up. Climate change is a serious thing, so lift your voices and help me sing. Remember, the bird in the tree and the fish in the sea are all depending on you and me. My inspiration for that piece is that the whole environment is hurt. Everything is hurt. All nature is hurt by climate change.
The first time I realized how effective artists can be, you know, of really using climate message fused with song was when I was a part of the delegation going to Paris, COP 21, you know, and I remember being in the Caribbean pavilion, and come lunchtime, you know, music strike up, and, you know, I started performing, and I was performing a song, you know, that was written by myself, you know, in the McClyman Lafayette and Petrie Arena, you know, and when we started, we pulled every other pavilion, I'm talking about the whole world was there, you know, and we pulled the whole pavilion, the whole other pavilion just came, and we were just looking at people, big cameras that I've never saw before, you know, just want to capture a piece of the song that I was singing, reggae music. You know what I'm saying? The whole thing, I can even sing a little piece of the chorus, please. You know, the song was going something like, Mother Nature is crying, for Mother Earth is dying, while the factories polluting, yes, climate change is happening. Oh, see the sea levels rising,
Stronger hurricanes are blowing, and what the farmers are farming, global warming destroying. It's getting hotter every day. Climate change is on the rise and it don't play. Got to keep it below 1.5 degrees. 1.5 to stay alive. That's what we need to survive. Yes. 1.5 to stay alive. Don't let it rise above 1.5, no. And when we left the evening to go on the train, everybody was singing this. 1.5, even on the train. When we were picking up our train tickets and things, people were just singing.
Speaking about sea levels rising, what you said in your song, we played out of Jamaica, right? And there's an area called Treasure Beach. So I would say maybe 15 years ago we started playing there, maybe 15, 20 years, because I know them big now, little watch and this and that. And the first time we played at that seafood restaurant, the famous, you know. All right, this is the bandstand here, yeah? And the sea was way out sound, you know what I mean? Bandstand here and the crowd is there. After maybe 5, 6 years, you know, you don't go there every year, but you go and you say, oh, the sea look nearer now. Probably not remember the place too tough, you know. About, I would say now in 2022, maybe about 2017, 2018, when we went down there to play, right? This is the back of the bandstand, yes? Where the post is. And usually the drum riser is right there. The sea was splashing water behind me. I said, what is this after being way out? But this is the level of the sea is rising and it come and it take over the whole thing, so much so that they had to move the bandstand. I think I've been here for a few years, but they moved it. Everything was wrong and they had to move it in until I think they try now do some kind of a barrier thing, artificial barrier reef to kind of hold the thing out. But you know, that is a practical, you say, what? You really couldn't believe it.
One of the most popular spots as a restaurant in Jamaica for many years is out at Prendies in Hillside. Remember, you went, you had your fish and you walk in the beach. No, you can have your fish and 1 foot in the beach at the same time. Yeah, it's unfortunate, but a lot of that is the same, is because of malpractice. We need to constantly be pushing these things and in different forms of the art, but definitely music as one of the, you know, the greater driving force to educate and empower people to, you know, make conscious, smart decisions.
A long time we are upset the ecology. No climate change is a reality. No strange weather changes all year round. We can't stop it, but we can slow it down.
Climate change could drive an additional 100 million people into poverty by 2030. The fact is, climate change impacts water and food security, coastal defenses, economic growth, and livelihood. UNDP's global mission is to eradicate poverty while protecting the planet. As such, climate change is one of the pathways we use to address this issue. This climate change education initiative was an opportunity to expand advocacy for climate action.
Since 2009, I think we're talking about when that nice climate change song with Love in There had come about. I think there has been heightened awareness among Jamaicans. More people are connecting with what's going on in climate change. There is this awareness among the general population at all levels, not only among the people in the communities, but among the government agencies, among everybody. People are connecting more with what is happening. People are living the experiences more and talking about it more. You can see people connecting more. I mean, when people talk about Elsha, they know exactly that it is, they can connect that to a climate event, sea level rise, the impact. When people talk about Little Ochi, they can connect that, sea level rise. When people see the revetment out at the airport now, they know why it is there. So that heightened awareness is being built up. Still a lot more to go, but I think there is this heightened awareness that something is happening and the climate is changing.
To adapt to the ever-changing climate, some lifestyle changes we got to make. Emission of gases we have to reduce. Turn off the lights when they're not in use.
The government has, since that time, 13 years ago, advanced a number of climate and climate-related policies. So, if you think about the emissions policy that was generated with the support of NEPA by our Ministry of Environment, the climate change policy framework through the Ministry of Environment as well, climate change vision, the energy policy, the national communications, the nationally determined contribution, those are all policy framework documents to guide the country's responses to climate change, both in terms of adaptation and mitigation.
Listening to all of you, and particularly when you share the stories of what's happening in Treasure Beach, what's happening in Hillshaw, it brings me to a fact, or actually something that scientists predict for Kingston, Jamaica. So there's this issue of climate departure, and pretty much what it speaks about is the fact that the warmest temperatures that we have now will at some point become our coldest temperatures in the future. And Kingston, Jamaica is predicted to be one of the first 3 cities to experience that. So whenever I think about climate change, that's pretty much something that bothers me and something that wants me to take, greater action. And so I just want to hear from each of you now, what is it that bothers you the most when you think about climate change and how it's, impacting Jamaica and anywhere else that you may visit on your different journeys?
For me, I think it's a term, will become. Will become would suggest that we have no plans of changing our ways and our attitudes towards best practices for climate purpose. So I think that's one of the most disturbing things, that the fact that people think that this will become and this, it doesn't necessarily have to, and we have to figure ways, innovative ways of getting the information out there, getting the facts out there, because as much as Grub was saying earlier about the powers that be ultimately rest with the people. A lot of times it's just informed decisions. So we just need to get the information out there to the people so they can make informed decisions. So will can change to something else.
It bothers me to see the people not disposing the garbage properly, and then don't realize that when the rain falls and the garbage goes into the wrong place, the rivers and the sea and places like those, it has a very bad impact on the environment.
And what bothered me too, the hesitancy of not taking the step as we see it. We need to be more active. As we see the problem, we need to solve it, because tomorrow we cannot solve it. I'm not talking about the government alone. We need everybody to be active when it comes to climate change.
The UNDP Country Program 2022 to 2026 has 4 pillars that have been tailored to contribute to the reduction of multidimensional poverty in Jamaica. One of these pillars aims to support resilience to climate change, including natural disasters. Under this pillar, UNDP will focus on strengthening policy and legislation, promoting renewable energy and energy-efficient technologies, and developing nature-based solutions to strengthen local climate change adaptation capacities. In line with the focus of our country program document, we call for the expansion of protected areas and forests, policies and programs to foster sustainable livelihood, more nature-based solutions to reduce land degradation, restore ecosystems and enhance climate resilience, and speedier transition to clean energy and energy efficiency.
Some simple actions that Jamaicans can take to tackle climate change starts with, I would say, drought mitigation. You know, looking at your water security. If you don't have a black tank, buy one. If you can build a tank or gutter your house to ensure that you're finding a way to capture water, because we will be having longer droughts. So we have to prepare for that. Energy conservation, that is very, very critical. You know, turn off your lights when they're not in use. If you can get some solar on your house to cut your electricity bill, these are very practical things that you could look at. And let's not forget planting trees. When we plant trees, we mitigate our carbon footprint. We have shelter, shade, so there are lots of benefits. Trees and mangroves, just replanting in general. These are some of the basic things that we can start with, in addition to educating ourselves continuously about the climate impact.
The other thing is about how we handle our garbage. We've been discussing a lot, and NEPA is supporting initiatives relating to plastics and plastic pollution. We can play a part in containerizing and recycling our plastics, and don't purchase single-use plastics. So we have important roles to play. Easy, but important roles that can have a lasting effect.
Jamaica is known for two things. Our athletics and our music, within the power of the artists, especially an international artist.
If it is that you want to take this movement of Voices for Climate Change education to the next level, what does next level look like to you? What should artists be doing? What is your vision for how music can influence change?
Engagement. We have to get other people engaged, especially the people from now. Generations speak better to generation, their own generation, just like we did. So I think we have to figure out how to get, you know, a more diverse and more youthful set of people involved in getting us to the next stage.
We should be going into the communities now, you know, and educating people about climate change, because it's that critical and it's that important.
13 years later, artists are still united for climate change action with one simple message: climate change is real.
There must be a solution for all this pollution. Climate change is real, it's no illusion. It's killing our world. When it dies, where will you stand? Unless you're planning to leave Earth and go live with mutant. Stop block the drains with plastic and juice pan or beautiful beaches. Every day we lose sun. The fossil fuel from the fire, can't you see it's too strong? Is it worth to kill Earth for a few grand? Mother Nature yearns for life, the more the factories burn. She cries, when will we learn and be wise? The more the ice cap melts, sea rise. Mother Nature yearns for life. Need your help.
We have to go green. We have to go green. 1.5 we need to stay alive. So go green, my people, go green. 1.5 we need to stay alive. Yeah, yeah.
Climate change, yes, climate change. Listen and learn about the climate change. Climate change, less climate change. For some things, we must rearrange. It is real, and the signs are all about. Real in the east, real in the west, real in the north, and real in the south.
So we nearly truly need to take a stand. So we really need another revolution. People, we need to truly take a stand. We really need another revolution before Mother Earth is all gone.
We are all in the same boat, people. Together we sink or together we float. And I also want to say there's no right way to do the wrong thing. So let us do the right thing deal with climate change now and never ever give up the fight for it.
We're losing the reefs and the beaches, flooded in the coastal communities. See the signs, they all reveal. So I said, that global climate change is real. Now warn you, it's not a matter of when or how. Climate change is happening now.
We want to help me sing along this part of we culture.